Hello students, welcome to the class. Today is the third lecture of Hindu law, which is about schools of Hindu law. Previous two lectures we have covered application of Hindu law, who are Hindus, and sources of Hindu law. In this lecture we're gonna do the schools of Hindu law. Okay, so let's get started. See, if we talk about the schools of Hindu law, so we have to keep in mind that this concept, it was applicable before the codification of Hindu law. At present we have Hindu law, modern Hindu law, which has been enacted by our parliament, and we have the uniform Hindu law which is applicable on all Hindus. Okay, now we are following the codified Hindu law, so there is no need of these schools in the codified Hindu law. But as this was the part of our Hindu law in uncodified Hindu law, so we should know about what are the schools. Okay, so if we are looking for the schools of Hindu law in uncodified Hindu law, there were two schools. Number one is Mitakshara school, and number two is Dayabhaga or Bengal school. Okay, Mitakshara school, it was further divided into four sub schools. These are Banaras school, Mithila school, Maharashtra school or Bombay school, and is Dravid or Madras school. If we talk about these schools in brief, so Banaras school, it is about this school extends to the whole of northern India except in rural Punjab, where there was the customary law which was prevailed in rural Punjab. Okay. About Mithila school, it operates in Tirhut and certain districts of northern Bihar. Okay, this is about Mithila school. And Maharashtra or Bombay school, it extends to the western India, including the whole of the presidency of Bombay as well as Berar. Okay, as the name indicates. So this was applicable on western India. Now next is Dravid or Madras school. Dravid or Madras school, it covers southern India, including whole of the old presidency of Madras. Okay, so these were the four sub schools of Mitakshara school. Now we'll be discussing about these two schools. This is not going to be very big lecture, because we just have to have to have the knowledge of these schools. These were in uncodified Hindu law. Today though these are not in the modern Hindu law, but we should have at least we should have the glimpse of these school. What were these, how these came in Hindu law, and how it affected the Hindu law, and why these are not there in codified law. These are not there in codified law because it has become a separate statute. Okay, now we'll be doing about these schools. If we talk about Mitakshara school, it extends, this school, it prevails in whole of the India except Bengal and Assam, because in Bengal and Assam, which school was prevailing? Dayabhaga or Bengal school. But the paramountcy of Mitakshara school was that if it is silent on some points of law, or it was not covering some matters on which it is silent. Let's do it again. If it is this school, if it is silent on some matters, okay, what this school will do, it will applicable on those matters on which this is silent. Okay, another point is that Mitakshara school, it is not merely a running commentary on Yajna Valkya Smriti, but it is also a digest of practically all the leading Smritis and deals with all the titles of Hindu law. However, this school, this is the digest on leading Smritis, but it deals with only partition and inheritance. Okay, and if we talk about these schools, what are the difference between these schools? So these schools are different on the basis of these 2 points, in respect of law of succession and in respect of law of the joint family. So how these are different, let's do the difference. Okay, so first of all, in respect of law of succession, how these two schools are different. First is Mitakshara school. It bases its law of inheritance on the principle of propinquity. Propinquity, what do you mean by propinquity? It means the one who is nearer in blood relationship succeeds. Okay. For instance, say there is a son and daughter, and there was a Hindu man who leaves behind son and daughter. Okay. So they both, son and daughter, they would succeed to the property equally and simultaneously, as they are equally near to their deceased parent. This is the principle of propinquity. One more example, if we say that there is daughter's son and son's son, they would also, take equally and simultaneously the property of their grandparent, right? But there was some, it did not give the full effect to this principle, this propinquity principle. It did not give the full effect to this principle. It further, it was limited by two further rules. What were these? They excluded the females. They excluded this school, this Mitakshara school excluded the females from inheritance. And the second was, it gave the preference of agnates over cognates. What are agnates and cognates? We'll be discussing about these terms while we'll be doing our, statutes in detail. Okay, these are the terms which we'll be studying in Hindu Succession Act, and when we are doing the Hindu Succession Act, we'll be discussing these later. So here we are just doing it in, in brief. So first principle is saying that it is excluding the females from inheritance. Okay, supposingly a Hindu dies leaving behind a son and a daughter. Okay, and by the application of this rule, the first rule, what was that? The exclusion of females from inheritance. The daughter is excluded from here and the son will take the entire property. Okay. Similarly, if a Hindu dies leaving behind, we are talking about this second rule, that the agnates are preferred over cognates. We are talking about this. So this is the example of second rule. A Hindu dies leaving behind a son's son and daughter's son. The son's son will succeed to the entire property and the daughter's son will be excluded by the application of this rule, because daughter's son is a cognate over here and son's son is a agnate over here, and this principle will be applicable because it is saying that agnate is preferred over cognates. Okay. However, Dayabhaga school, it bases its law of succession on the principle of religious efficacy or spiritual benefit. What does it mean? It means that who is giving more religious benefit to the deceased is entitled to inheritance in preference to the others. Who are in preference to the others? Who are others? Who are not conferring that much religious benefit, how much the previous one is giving. Okay. What kind of religious benefit one has to pay to the ancestors? By doing the oblations, by offering the oblations. Oblation, what are the oblations? Pinddan, to the deceased. Okay. Although this principle, it is based on religious doctrines, its operation, it does not always lead to agnates over cognates. This does not prefer agnates over cognates. It is preferring the one who is giving more religious benefit to the deceased by doing the pinddan, okay, or by offering the oblations. Both are the same thing. Okay, but under Hindu law, this difference between these two schools is no longer tenable, because we have the Hindu Succession Act 1956, which is the uniform law, and this is a uniform law of succession, and it is applicable to all the Hindus. Okay, to whatever school or sub school he or they may belong. Okay. Now the second part of difference, which is with regard to the law of joint family. Okay, here the Mitakshara school, it propounds the son's right by birth in the joint family. The doctrine, what is the doctrine of sons over here? He is preferring son's son and son's son. Their right by birth in the joint family property. Okay, And you can say that this was the unique contribution of this school to the Hindu jurisprudence. Okay. And this doctrine, this son's doctrine, what does it say? It means that whenever a son is born in the family, he acquires an interest in the joint family property. So whenever the partition takes place at any time, even after just even after the moment he has got birth, after that the partition of the property takes place, that time his that joint family property, it can be converted into separate property, because the son, when he has got the birth, he has the share in the joint family property, and if there is a partition, he will get his share, and once he get his share, that will become his separate property. Okay. However, in Dayabhaga school, the doctrine of son's birthright and devolution of property by survivorship, it do not find any place in this school. Okay. And how the property gets devolved over here in this school, to the person who are governed by this school, by the inheritance. Okay. So long as the father is alive, he is the master of all the properties, whether that property is ancestral or whether that property is self acquired. Birth giving the birth of any son does not affect his right. The father will be the master of all the properties. Okay. Another point you may say, that here, if we talk about Mitakshara school, as the son, the birth of son is giving him the right in the joint family property. So here, don't you think that the interest of each co-partner is a fluctuating one? Because how it is fluctuating, because if there is a death in the family, that may augment his share, and if there is the birth of a son in the family, that may diminish his share from the property. Don't you think so? For example, see, if there are more births of the son in the family, so that means there are more person having the interest in that family. And if at that stage, whenever there are more person who are there are birth of more male members in the family, what will happen? If the partition takes place, their share will be less, and if death takes place, their share will be more, right? So here, that is why here the share of the co-partner is fluctuating one, right? And since there is no concept of birthright under Dayabhaga school, co-partner, they have some specified and ascertained share in the joint family property, and their interest, these are not fluctuating on birth or death in the family, right? Because they are, this principle, the son's birthright, this principle is not applicable in this school. And under Mitakshara school, neither the father, in this school, we are talking about this school in respect of law of joint family, in this school, neither the father nor any other co-partner can alienate the joint family property. And however, in this school, they can alienate the property, because they have the full right of alienation of their undivided share, right? So guys, this was the difference of a very good difference between these two schools, and the factors on the basis of which these schools are different, it is in respect of law of succession and in respect of joint family. Okay. Now there is a little bit concept of this migration and domicile, though it is not important, but I have written 2 to 3 lines of these two. Let's do it. What is migration? Everybody knows what is migration. Migration is moving from one part to another. Okay. And if we are talking about migration in the Hindu law sense, then we will say that when a Hindu, as we are talking about Hindu law, when he is migrated from one part of India to another, prima facie, he carries with him his personal law. And if it is alleged that he has become subject to the local law, then it must be affirmatively be proved that he had adopted the Local law, very simple and very easy. If one person, supposingly a person, he is migrating, supposingly, just leave it. This is a family. This is a family who is migrating from Banaras. Okay, and in Banaras, while we were doing the sub schools, I told you that in Banaras, Banaras school was applicable, and this family is governed by. Just a moment. This A family, which is from Banaras, it is governed by Banaras school. Okay, what if this family, it migrates from Banaras to Bengal? Bengal. Now, what will happen here? Will Dayabhaga school be applicable on this family while this is migrated from Banaras to Bengal? No. The prima facie, this family be applicable with his own personal law, which it was applicable in his own place. Okay, originally what he was applicable with, he'll be applicable by that personal law wherever he gets migrated to. Okay, if he is governed by Banaras school, if he gets shifted to Bengal, Dayabhaga school will not be applicable to this family. They will be governed by Banaras school only. Okay. Now, second is domicile. Domicile, you know, domicile is, what is a domicile? You must be having your residence certificate, which shows that what is your domicile. Domicile is a place of residence, right? So in this, the Privy Council, very early, Privy Council, very early, what it observed, if nothing is known about a person except that he lived in a certain place, it will be presumed that his personal law is the law which prevails in that place. Supposingly, there is a person A and he is living in a locality where any of the school is applicable, either Mitakshra school or Dayabhaga school. Any school may be applicable over there. Okay, and nothing is known about this person who what he is governed by, which school is applicable on him. Okay, if he is living supposingly in a locality where Mitakshra school is applicable, then it will be presumed, when the presumption will come into existence, that will come into picture only when nothing is known about this person, that what are the personal law of this person. Okay, then only he'll be governed by that school. That is the presumption, that if nothing is known, then only he'll be governed by the rules and regulations of the custom, rules and regulation, or you can say the personal law of the place where he is living. Okay, which prevails in that place. Okay, students, that was all. This was all about this lecture. It was a very short lecture because we had to do the schools of Hindu law. And as this was a part of uncodified law, you're not supposed to do that in detail, because question will not come in that detail where you have to write a 20-mark question over this. I think if 5 or 10-mark question comes from this part, this is the sufficient material you have. You can take the screenshot of these slides, and obviously you have to listen to the voice lecture as well. From there you can make your notes. Okay, I have written very less in this part because it was very difficult to bring all the points over here in one slide, right? So though it is not difficult, if you go through the voice lecture, you will make your notes very easily, right? So we are ending our lecture over here. Thank you so much for watching. Just stay tuned for the next lecture. Thank you. Bye bye.